Hata yangu jana ndio ilikuwa inasema.
Pia ya nani huyo anaongea?
Ya base inasema tu hivyo.
Pia yangu imenisumbua hata login, sijui shida ni nini.
Nikaa ni system yao iko na shida. Si hata yangu jana ilikuwa inasema hivyo.
Hata login.
I'm back. I'm taking back the class. You are well?
Yes.
Sorry, I've been held up in another meeting where I was a rapporteur. But it's good you've hung in here. So shall we?
Yeah.
Yes.
Yeah, I'm informed that the specials were starting today. The special examinations, huh? So the portal seems low, but they are working on.
Oh, that's why it's not working?
I suppose, but they are working on it. The IT department are trying to normalize.
Oh.
Yes. So I think they should communicate. Standard maintenance. So here we are. Mwasi?
Yes, sure.
You need to give back my rights. Oh, you given?
Yeah.
I see when you are the host, I can't even mute or unmute. How was it?
It was good.
It's good at times to accept responsibilities. How far have you gone? You see, making you the host was to mean you take over the class. How far are you gone? Don't tell me.
We have not started yet.
Now you converted my class into a working meeting. Anyhow.
No.
Let's see what we can do.
It's okay.
Yeah, you've seen the notes? I want to be very brief. You realize that in these units, it's more of learner-centered. Have you realized that? It's more of learner-centered. By learner-centered, I mean, you see, you have now to conceptualize and understand these things. Isn't it? It's more of learner-centered. So what I'll be doing is just trickling in what I already have. Our topic 2 is supposed to check on the types of gifts by way of will, and there are 4. In summary, I'm sharing the screen. You can see the screen. So our topic is on legacies, gifts, and grants. And we have the 4 types. We have the special or the specific legacy. We have the general, we have the demonstrative, and we have a gift of residue. Now we say that a special or a specific legacy is that gift that is particular, or you can say it is what now the testator will in particular identify and give a description. So when we talk of specific, now it should be all the testator must, for example, in our notes, we've been given, I leave my house in Buruburu, Nairobi, to my eldest son, Owino. You see, it is very specific. What is being left is a house. It is situated in Buruburu, and it is being left to a beneficiary called Owino. It is specific. Then we have a general legacy, and this is where, now by general, we mean it is not specific. So you cannot really tell that this is what the testator has left to the beneficiary. But we say in legal terms that whether specific or general, the property described in the general terms should be provided out in the general estate of the testator. For example, I leave 200,000 shillings to my youngest daughter, June. Or I leave a bicycle to my son, Juma. So see, the testator is talking of my bicycle, not the bicycle. There is a difference. So when you are studying English, when we say there means that you can identify with that bicycle. So by there, it becomes specific. But when we say I leave a bicycle, could be the testator had like 5 bicycles, but one of them will be left to the son called Juma. So not specific one. One of the 5 bicycles will be left to. So when the testator says, I leave 200,000 to my youngest daughter, we don't know where the 200,000 is. Could be it is in the property, could be in shares, it could be cash in the bank, etc. So all that we know is that June will get 200,000 from the wealth of the testator. So when we say a pecuniary legacy includes an annuity, pecuniary means monetary. So we are talking of the money that may be paid regularly or may be paid as a lump sum. Then we have a demonstrative legacy, and this is where the examiner normally dwells much on. So a demonstrative legacy is that testamentary gift which in its nature is general, but manifests an intention that the gift shall be primarily satisfied out of a specified fund. So this term, when we talk of demonstrative, it means that the will is demonstrating where that amount will be coming from, or where that particular legacy will be coming from, or the gift. So we want the testator, or when the testator has specified that this part of the property, and you've been given an example, let me see in the notes. I don't know whether this slide has the notes. Yes, we have the notes here. Yeah, so you can see what is happening. A demonstrative legacy is a testamentary gift which in its nature is general, but it manifests the intention. For example, A leaves 100,000 to B, payable out of his holding of ordinary shares in Kenya Breweries Limited. So the testator is very specific. Out of the shares that I hold at KBL, shares worth 100,000 will be given to B. So he goes ahead and demonstrates. Now the challenge will be if there are no shares in KBL, because it will convert. Now it is demonstrative to mean that this amount is in KBL. But if there are no shares in KBL, and you can see down there, we've been told at the time of his death, then the gift of 100,000 will not fail to redemption. When we say that it failed due to redemption, we'll be coming to redemption later on. But it means that the lack of the 100,000 worth of shares from KBL will not necessarily make this legacy not available. What will happen is it will convert from the demonstrative into general if there are no shares. So if A shares in KBL can realize only 40,000, then 40,000 is deemed to be specific because it was demonstrated in the legacy. But the 60,000 will not be redemptive. Haitapotelea. To redempt means that it ends there. So the 60,000 will still be paid, but from the general legacy. So we'll go back to the wealth of the testator, draw 60,000 and pay B, because A had indicated that I am paying you this amount. Are we together? And we can relate to a case of Mullins versus Smith, where it was said that 100 consoles out of 500 was to be paid. We also have another case of Boyd versus Boyd. But I want you just to understand that in demonstrative, the testator is very specific, that the gift that I'm giving will be coming from this particular kitty. But if that kitty is not able to clear the demonstrative legacy, then you are going to get it from the specific or from the general legacy, in that order. And then the last one is the gift of residue. And the gift of residue, we say that when the property is not given by a specific legacy or by a general legacy, it makes up the residue of the testator's estate. To mean, if let's say the testator made a gift out of all before he died and he didn't specify, then the residuary bequest or what will remain from what will be disposed of by the specific, followed by the general, followed by the demonstrative, is what we are going to call a gift of residue. So it means that the testator failed. So he died intestate. You can say it is a partial intestacy. He didn't describe how he'll want his part of the wealth to be shared. That's why we are calling it a residue. So he was able to demonstrate the specific, the general, and the demonstrative. But partly, his estate is not shared to anyone. That's what we are calling the residual. So a gift of residual is what is not described in the other three categories. Then we have the interest that are given under will. We have the vested, let me display. We have the interest given under will, and when we are talking of the interest, we are talking of gift of residue that is not now explained in the three categories, the specific, the general, and the demonstrative. And you have the vested, and we normally use this term when we are talking. We talk of, I have vested interest. So this is what it means in law. So a vested interest gives immediate, indefeasible title, although possession might be deferred. By deferment, we mean, could be you will not realize the interest today, but it will be realized later as a remainder man. What is remainder man in law? I'm assuming that you people had gone through this. What is remainder man? Who is a remainder man? Remainder man? So a remainder man will be the person who inherits or is entitled to inherit the property upon termination of the life estate of the former owner. So we are talking of an illustration is the interest of a remainder man while the life tenant is still alive. A good example is, let's say you are living in a house where you pay rent. And of course, the landlord is the owner. So the assumption is, unless you have given a notice, the landlord will keep on wishing that they are going to receive your rent for next month. So when we talk of vested interest, it means that whoever the beneficiary is or is recognized in the legacy assumes that there will be going concern. If that property was attracting some income, that income will continue to flow in. The cash inflow will be there. So when we are talking of the remainder man, we are talking of the property whose life estate will continue giving the cash inflows even after the deceased person. And then we have the contingent. A contingent interest is dependent on the happening of some specific, and that's why we are calling it the contingent. An example will be the interest of the second life tenant of a trust while the first is still alive. So we are talking of a trust, and we'll be coming to trust laws. So allow us to venture into the contingencies when we come to the trust. But what I mean is, when we establish a trust, in the wills, we have the executor. So executor, when the deceased person is gone, is in charge of the estate or the property of the deceased. So they continue operating as if all in the interest of the deceased until it is passed over to the legatee or the beneficiary as identified in the will. Are we there? When we are talking of a trust, the deceased identifies a trustee when they are still alive to continue demonstrating or being responsible of their property when they are still alive. So when we are talking of the contingent, this is dependent on the happening of specific event. And you said an example will be interest of the second life tenant of a trust while the first is still alive. Trusts are normally, it involves a lot of calculations. We call them actuarial mathematics. For example, you don't know whether a property will continue giving you income some 50 years to come. So although you are living today, now you cannot share what you don't have. Are we together? So we don't expect the testator or the person who is to do the will to identify that this property 50 years to come will be able to give this amount of money. But again, they cannot assume that once they die, or after a property, let's say, has a shelf life of 20 years, it will not bear any more income. So we are talking of postulating that second life tenant of the trust while the first one is still alive. So you are receiving the current, but you are not assured of the next. But you are going to provide for it anyway in your residual gift. So that's what we are calling a contingent. Then we have the absolute. An absolute interest gives full power over the property, including the power to dispose. When we say absolutely, we mean whole. So that power is not shared. It's given you the authority to go ahead and do the full disposal of the residual gift. And these are the powers. We'll be coming to the powers and the responsibilities of the executors later on. Then limited means that you are only given partial and you can only enjoy that for a period of time. So the executor will be given some limits. Like if I die, I give you like 5 years to take care of my estate, then pass it over to the beneficiary or the people who are named in the will. And then conditional. A conditional interest is dependent on the beneficiary fulfilling some condition before the title is made absolute. Of course, this will be provided for under the will. And then the last one, you have the cumulative. And when we talk of the cumulative, or the substitution or legacies and devices, this is where a will makes two gifts of an equal amount to the same person. So they are assumed in the absence of the contrary indication to be cumulative. So where a will makes two gifts of equal amount to the same person, we presume that the second was in substitution of the first. Now this is law. For example, if I say I'll bequeath B, let's say I'm the testator. So A identifies in the will that they are going to bequeath B, let's say 500, a gift of 500,000 Kenyan shillings. But they have indicated that they are going also to gift B worth 500,000 worth of shares. You see, it is one and one gift. Only that the first one was indicating that they are going to give 500,000, but the second one is very demonstrative. I'm giving 500,000 worth of shares. So if two clauses of the will are irreconcilable, if we cannot really reconcile, In other words, we are saying that they are not equal. Obviously, the clerical errors have to be corrected. So when we are talking of the cumulative, we are talking of, let's say A said at some point, I'm going to give, let's say 200,000. And then in shares, I give 500,000. So if we combine, not 500, 300. If we combine the two, we are going to get 500,000. So you can see the difference between the substitutional legacies and the cumulative. So whereas the first one is cumulative, because you are going to take the cash of 200,000 and add now the 300 worth of shares to make 500. The second case, the example I've given of A bequeathing B 500,000 and also indicating in the will it is 500 worth of shares. This is substitution. So where the amounts are equal, we substitute. We assume that the latter substitutes the former. But where the amounts are not equal, we accumulate. Do you have any question? So I'll ask you in the exam to differentiate between cumulative and substitutional legacies. So cumulative means we are adding together what the testator has given as not equal. But what was given as equal, but the amounts now are appearing, or the gifts of the equal amounts, we are going to presume that the latest in the will is what the testator intended to bequeath the beneficiary or the legatee. Any question? So we go on. We go now to the causes of failure of legacies. Because what normally happens is a challenge comes in when the will was not explicit, or when the will was general and not demonstrative. This is what now causes the issues of, or what we are calling the ademption, uncertainty. We have disclaimer, we have the lapses, and we need to understand all these terms. So when we are talking of the ademption is to mean that it's withdrawn. The gift is no longer there. So if a property which had been specifically bequeathed does not belong to the testator at the time of his death, or has been converted into property of a different kind, then the gift cannot take effect. And this is common sense. Now, if I had given you a car, and then in the will, I have indicated that I leave my car to come out when I die. And then before I die, I dispose of my car. Then the will is inconsequential because there is no that car to be given. Are we together? So it withdraws, it is automatic. Once I dispose of the car, it is no longer existing to be bequeathed in the will. And this is what we mean by addeemed. So when it is addeemed, it means that it is withdrawn. The will is not operational. So there must be a substantial change in the subject of the specific legacy to cause ademption. And we are talking of merely nominal change shall not have that effect. So it must not be there for it to be addeemed. And we go further to say, the gift of an interest in a fund shall not be addeemed by any sale or change of investment of the fund by the person having control thereof. Nor shall it be addeemed by the testator receiving it before his death, whether or not thereafter sold or invested by him, if it can at his death be followed and distinguished. In other words, we are saying, if it is transferable, or if it is within the control of the testator, we cannot addeem it. It can only be addeemed if it is withdrawn from the control of the testator. If you recall, when we were talking of the stripes rule, we indicated that the wife, not the wife, we indicated that the assumption of the law is that the testator must identify a beneficiary before they die. Now, when they identify and recognize this in the will, and let's say the gift that was to be gifted is in investment, and we know people have different portfolios of investment. For example, if you are in real estate and your work is to purchase and sell properties, and you've indicated in the will that your property will be given to your son A, and then somewhere on the way, you disposed of that property, but invested in another property, that will not addeem what had indicated in the will. Are we there? So by ademption, we mean it's no longer there. It has no, or the testator doesn't have any control. So that asset or the property in question has left the portfolio of the testator. But if it is there or it was transferred in another form by the time of the death, then it will be demonstrative. And we have indicated there, if you look at the preceding paragraph, a demonstrative legacy is not addeemed if the property on which it is judged by the will does not exist at the time of the death of the testator, or has been converted into the property of a different kind. In this case, it is paid out of the general estate of the testator, as so long as it was identified in the initial will, and that will has not been revised. Then we will assume it was demonstrative and it will be paid as part of the general estate of the testator. Are we together? And we continue, where a testator makes a gift by will to any person for a specific purpose. So it is specific gift, or to any child or other person to whom he stands in loco parentis. And this is, there are those people, if you will not attain the majority years, of course, someone will be in place to ensure that your interests are catered for. And after the date of execution of the will, provides by deed or settlement or otherwise for same purpose, or by way of portion for the same child or other person, there shall be a presumption that the gift is addeemed by the subsequent provision, so far as the subsequent provision extends. So if it was specific, initially we are talking of the demonstrative, and we can see in this case is being now passed on from the person who was taking interest. Is a case of a minor. So where it is very clear that it was specific and it has been withdrawn, then it should be provided for us to accept that it was addeemed. So ademption is also an area that will be tested. Then from the ademption you said it is the withdrawal of the operation of the will. We have uncertainty. Now, a gift or disposition not expressive of any definite intention shall be void for uncertainty. Now, uncertainty will occur when what is given is not clear, to whom it was given is not clear, and the quantity of the interest being given is not clear. So if we don't know what we are being given, or the amount is not clear, then it becomes so uncertain and it will fail. We cannot give what has not been identified. So a gift or disposition not expressive, and by express we mean written down. You see, when we were saying that the testator is very general, saying that I leave a bicycle to Juma, we know it is a bicycle, so it is not uncertain. Are we together? So we know it is a bicycle and it is being left to Juma, and the testator had several bicycles, so that one is certain. But what is not expressive, it puts us in a situation that is uncertain and therefore cannot apply. It will fail. Then, for example, there is an example given there. A leaves some of his property to B, or A leaves his house in Karen to some of his children. However, no gift for charitable purposes is void because of uncertainty of the object. So we can see that A leaves some of his property to B. Which property? It is uncertain. However, no gift for charitable purposes is void. If, for example, the property in question, or when we are told that A leaves his house in Karen to some of his children, which children? It is not certain. So it puts us in a situation. But if this was left to a charitable organization, you see, charitable organizations don't belong to any person. They belong to the community. So there is certainty in a charitable organization. Also, no gift whereby the legatee is expressly or impliedly given a right of selection, purchase, or disposition is void merely by reason of uncertainty arising from the right. In other words, we are saying that when the legatee is impliedly given the right of selection, you see, the testator could be rich and have several houses. So let's say I have 4 sons and I have 4 homes, one in Kisuru, I have another one in Karen, I have another one, let's say Greenfields, I have another one in Muthaiga. And I've identified that for each son, I leave a house. They can agree and choose rightly because they are recognized in the will. So where the property is bequeathed to any person, the gift shall be presumed to comprise of the whole interest of the testator in that property, unless it appears from a will that it was restricted interest. If, for example, I say in that house, I've only given, let's say there are 3 floors, and I've said I've given you only the upper floor, it means that you have only the right to upper floor. The first and the second one, you don't have any right. Or if, let's say, in that particular piece of land, there are 3 houses, and I bequeath one, is very specific. So the object of the gift, which refers to the person or person as existing, shall be construed as at the date of the will, unless the contrary intention clearly appears therein. So the will should be very certain on what is being given, otherwise it will cause a failure. Then you have disclaimer. A beneficiary can always disclaim a legacy and probably would do so if the gift involves onerous condition. And when we are talking of onerous condition, we are talking of, let's say, a difficult. It's difficult to now analyze. Now, he may also do when he wishes to increase the share of residual passing to some other beneficiary. So it will always be very hard if it is difficult to spell out the gift in the will. So a beneficiary can always disclaim a legacy and probably would do so if the gift was being given or there were difficult conditions prevailing for the will. And then you have the lapse. If the legatee or the beneficiary predecesses the testator, then the gift fails. In other words, we say that it has lapsed. In other words, if, let's say, A gives B, but B dies before A, then that will lapses at that point. So in his will, A leaves B shillings 100,000, but B dies before A. Since it is useless to pass money to a dead person, then we'll say that the will has lapsed. But we have some exemptions to the rule of lapse. There is no lapse in the following cases: where the gift or disposition is made in discharge of a moral obligation recognized by the testator. And 2, where the gift or disposition is in favor of any child or other issues of the testator for any estate or estate not determinable at or before the death of the child, or other issue, and the child or other issue leaves issue surviving the testator. So we are saying in either case, the gift of disposition will take effect because the deceased beneficiary died immediately after the testator. So you can imagine a case where you are coming from, let's say, Rorashio. The father is in the car, the mother is in the car, the son is in the car, and the son is the beneficiary identified in the will. But it happens they all get into an accident and all of them dies. So what are we going to say? Who died first? So in this case, we assume that the father died first, followed by the mother. Now the law assumes that the father and the mother are one thing if they are married. So they died at the same time, then the son followed. And you've been given an example. In his will, K left his house to the eldest son M. M predeceases his father but leaves his children P and Q, who are alive at the time of his father's death. In his will, M leaves all of his estate to his wife, Mrs. M. Now, the fact that P and Q are alive at K's death keep in place the gift to M. The house passes to M's estate, and by means of M's will, passes to Mrs. M. And here we are asked to be careful on the prescribed rule. If you recall, I said that in Hindu community, we don't recognize the spouse, we just indicate. Let me just show you the, here is the example that I'm talking about. So we are saying that in his will, K left his house to the eldest son, M. M predeceases his father, but leaves his children, P and Q, who are alive at the time of his father's death, or K's death. So in his will, M leaves all his estate to his wife, Mrs. M. So the fact that P and Q are alive at K's death keep in place the gift to M. Are we there? So it won't lapse because they are beneficiaries who are children in the name of P and Q. So the house passes to M's estate, and by means of M's will passes to Mrs. M, now the wife. And we are being told to be careful of the stripes rule of intestacy. So here it is written. So we cannot follow the intestacy rule because it is indicated that when I die, all my interests will pass on to my wife. But you see, the son will not be forgotten because there exist the heirs who are P and Q. So it won't lapse. Then we have gift subject to an illegal condition. Now, where there is a gift that has been given through an illegal condition, for example, I give 100,000 to Mwangi provided he murders his housekeeper. It will not take effect. It will fail. Now, you cannot tell people to go and kill others, which is illegal, for them to be gifted. So gift subject to an illegal condition, fail. Now, gift subject to a condition which is contrary to the public policy will also fail. For example, I give 1 million shillings to my wife on the condition that she shall not marry again. Now, it is illegal. When you are dead, you cannot be that selfish to command that you will only give to your wife when you are dead. Now, it means that the wife cannot be married by another person because it's like you are buying the right to be married by another person. So the law will still give to the wife the 1 million, but they'll be allowed to marry again. You can see how law is protective. In other words, we say that the law always takes precedence. So you cannot buy in the rights of a person because you've gifted them or you are leaving a legacy to them. Then we have gifts subject to, we have abatement, which is the last one. And to abate, abate means fail. So abatement, in case the legacy is not adequate to meet all the dues of the beneficiaries, the dues will be reduced in proportion to what is available from the legacy. For example, if the deceased person had written a will of 10 million and the net worth is only 2 million, we cannot really share what is not there. So what we can do is to apportion. If, for example, in the 10 million, A was taking 30%, we will get 30% of the 2 million that is available. So we can look at the abatement of policies. So we are saying that if the assets, after the payments of debts, necessary expenses, and specific legacies are not sufficient to pay the general legacies as identified now in the will, then the latter abate in equal proportion and personal representative has no right to pay one legatee. You cannot pay only one person. You have now to proportionately pay. So for the purpose of abatement, a legacy for life, a sum appropriated by will to produce an annuity, and the value of annuity when no sum has been appropriated to produce it shall be treated as general legacy. In other words, let's say the deceased was very sure that the property that they've left, an annuity is a regular amount that will come every month. That's an annuity. We have Rebecca, I'm sharing my screen. Am I not? Rebecca, I'm talking to you. Rebecca, I'm talking to you. You are saying I share my screen. I'm sharing my screen. Rebecca.
Yes.
I'm sharing the screen. Or what do you mean by sharing the screen?
Oh, you are running behind.
Yes?
You are running behind.
What do you mean by running behind? I'm explaining the notes. Now my assumption is, Rebecca, you've gone through the notes. Do you want to mean that you are going through them as I take you through the class? It's like reading when the teacher is explaining something. Where need be, I'm giving examples, isn't it? Now the challenge of sharing the screen, it will make you'll see, you lose the concentration. Let me try. People will be looking at the screen and not listening. So my mode of delivery was meant to keep you keen. Now see, when I put we are in the abatement of legacies. No human beings, we are naturally egocentric. Now I know people are reading the notes. Isn't it? I know people are reading what is in the screen. They won't listen. So I can keep on talking everything, but they won't listen. I'm very sure right now people are looking at the notes. Sinukweli, Rebecca.
Yes.
That is abatement.
For easy understanding.
Yes?
For easy understanding.
Well, it's okay. Explanation is better than reading. You will believe me. You heard all these notes. The notes are shared in the portal, but it's okay. So I'm saying for the purpose of the abatement, a legacy for life or I was talking of an annuity, where the testator had indicated in the will that you'll be paying, let's say, a certain amount, let's say 10,000 per month, because they knew the property was giving such an annuity or a regular income every month. But we cannot be able to produce that amount right away. To mean, when they are deceased, the property misbehaved. They cannot give that annuity as it had appropriated. So what will happen? We can only treat this as a general legacy. Well, we won't fail to pay, but we cannot pay it as an annuity. So that annuitant who was expecting, an annuitant is someone who expects now to be paid this amount every month. Because the property cannot bring that 10,000 every month, we can only pay you from the general legacy. So it could pay you half yearly, it could pay you a whole year, depending on the availability of the funds. So we won't deny you, but you can see the legacy is already failing. When we say abate means decline or fail to meet the conditions as per the will. So where there is a specific legacy and the assets are sufficient for the payment of the debts and necessary expenses, the thing specified must be delivered to the legatee without any abatement. So we are talking of where it is specified and the funds are available. It will only be sufficient if we honor the payment of the specific legacy. So we are talking of the specific legacy and we have sufficiency. So you'll go ahead and pay, it won't fail. Now, where there is demonstrative legacy and the assets are sufficient for the payment of the debts and necessary expenses, the legatee shall have a preferential claim for the payment of his legacy out of the fund. You see, it is demonstrative. You said, if you recall the case of the KBL shares, he had indicated that the testator want 100,000 worth of shares in KBL to be paid to B. Now, if these shares are there, why don't we pay? You're supposed to give preference. Although there could be other expenses that need to be met, but because it was demonstrative, the shares have to go to the legatee or the beneficiary identified in the will. Now, if the assets are not sufficient to answer the debts and the specific legacies, an abatement shall be made from the latter rateably in proportion to their respective amount. And this is what I was talking about. If the money is not sufficient to clear the legacies, we are going to apportion. The testator had in the will indicated 10 million. We can only realize 2 million from his property. So we can only apportion the 2 million because the 8 million is not there. Although the will is saying share 10 million, it is only that we have 2 million that is shareable. So we are going ahead and apportioning the 2 million that is available. And that's why we are talking of these, it's not an English word, rateably. So we are going to prorate. In accounting, we talk of pro rata basis. So if, for example, in the 10 million, you had been given 3 out of the 10 million, that is 30%. So you'll come in there, 20 million, and say 30% of 20 million, and give you the 30% of the 20 million. If another person was getting 10%, we'll give them 10% out of the 2 million, because the 10 million is not there. So where personal representatives have given such notice as may be prescribed for creditors and others to send in their claims against the estate of the deceased, the personal representative can distribute. Sorry. Let me plug in power. We go on. I was saying where the personal representative had given such notice as may be prescribed for creditors and others to send their claims against the estate of the deceased, the personal representative can distribute the assets of the estate at the expiration of the time stated. So they shall not be liable for assets to so distributed. They shall not be liable for the assets so distributed to any person of whose claim they have not had notice at the time of distribution. So the creditor or the claimant has the right to follow their debts. In other words, we are saying, and you've heard this in the funerals, which is not a good gesture. So you heard the master of ceremony indicating that kama kuna mtu kulikuwa na deni yake, aone familia, yeah, immediately after the burial. To mean, if there was any outstanding creditor, they need to report before the executor goes ahead and distributes the assets of the testator. Because if you've not brought forth your claim and the money is shared, then you cannot come and say that I had this pending credit that I want to be cleared. I think that is self-explanatory. So where personal representative have paid any legacy, which but for the payment would have been liable to abatement as above, they shall be entitled to call upon the legatee to refund the amount. In other words, we are saying if mistakenly you paid what was not supposed to be paid, now the legacy can be recalled. So the legacy was paid under any order of the court, but they later realized that it was not okay to pay. They can recall. Now, if and so far as the abatement is rendered necessary by discovery of a debt of which the personal representative had no notice at the time of voluntary payment of the legacy. So in other words, we are saying that if we have received a claim and we had gone ahead and shared the legacy, right? But we have received a claim of a debt that needs to be cleared and we've discovered so we can recall and pay. In other words, we are going to abate the legacy that had been extended to the legatee or the beneficiary. Now, we have presumption of survivorship, and this is where I was talking about you are coming from a Rurashio, or you are traveling for a get together, then midway, an accident happened. So where two or more persons have died in circumstances rendering it uncertain which of them survived the other, all others, the death shall for all purposes of Succession Act be presumed to have occurred in order of seniority. And accordingly, the younger shall be deemed to have survived the order. However, in the cases of spouses who died in these circumstances, the spouses shall be presumed to have died simultaneously. So you are in that car, the car is carrying the father, mother. Let us call them A and B, or A and Mrs. A. And they are sons B and C. And the sons B and C have children P and Q, respectively. So we are carrying 3 generations in one car. Then they happen to be in a fatal accident and they all die. We will assume an order of seniority. So for purposes of clearing the will, we will assume A and Mrs. A died first, followed by B and C, who are sons, then followed by P and Q. Now it will be confusion if we assume they all died at the same time. So who will survive who? So for purposes of ironing out the issue, the death is assumed to be in order of seniority. So the parents died first, followed by the sons, followed by their children. And in this case, we assume that the father and the mother died at the same time. So that is low for purposes of clearing out the issue of survivorship. Then we go to investment of funds to provide for legacies and interest on legacies. And they are there. We are saying where a general legacy is given for life, the sum bequeathed shall at or before the end of the year after the death of the testator be invested in any authorized investment. However, when an annuity is given and no fund is charged by the will with its payment or appropriated by the will to answer it, a sum sufficient to produce the annuity shall be invested in any authorized investment. That is very clear. In other words, we are saying that if it is provided in the will that this amount before the end of the year of the death of the testator, then the executor will invest that amount, but they make sure that they honor the annuity as at the end of the year. So they can go ahead and invest. So where a general legacy is given to be paid at a future time, the personal representative shall invest a sum sufficient to meet it in any authorized investment. In other words, we are saying that if it is indicated that you are going to receive your general legacy, let's say some 10 years to come, the executor can put this in a portfolio of investment, but make sure that they pay you your money as at the end of the postulated future time. If it is 10 years, we expect that after the investment is there for 10 years, they'll be able to pay you as at the end of the 10 year. And in this case, we don't expect to hear stories. We are saying the intermediate interest from the investment shall, unless expressly or by implication, be payable to the legatee or another form part of the residue of the testator's estate. In other words, we are saying the testator indicated we pay you 10 million at the end of 10 years. Then the property, or where we invest this amount, we get 15 million. We can only pay you as per the general legacy. So we are going to pay you 10 million. The 5 million that the property has generated will be taken to the residual part of the property. Thirdly, where a gift is contingent, and we had the contingent, the personal representative shall not be bound to invest the amount of the legacy, but may transfer the whole residue of the estate to the residuary legatee, if any on his giving sufficient security for the payment of the legacy, if and when it becomes due. So if it is contingent, it is wholly residual. You don't have any business to do with it. We just transfer it to the legatee as at the end of the period. So where a testator has given any property to a person for life without any direction, in other words, it's general. It does not. There is some level of generality. We are not indicating the amounts. So where a testator had given any property, has given any property to a person for life without any direction to invest in any particular securities, so much thereof as is not at the time of the testator's death invested in an authorized investment shall be converted into money and invested in such investment. So until conversion and investment are completed as above, the person who would be for the time being entitled to the income of the fund when so invested shall receive only 6% per annum upon the market value of the testator's death of such part of the fund as has not been so converted and invested. In other words, we are saying if the will has given the executor the powers to invest, and as at the time of the death of the testator they had not invested, and they take some time before they invest, the beneficiary of the legatee will be getting 6% per annum until we invest. You see, when you are investing, it does not guarantee you income or future returns almost immediately. But to make sure that we cushion the beneficiary, We are saying that this person should be given 6% per annum of the amount that is to be invested as they await for the executor to invest that amount. Are we there? So a contingent of future as well as immediate specific legacy and a residuary bequest not contingent in its sum of property, whether immovable or otherwise, shall carry the intermediate income of that property from the death of the testator, except so far as the income or any part thereof may be otherwise expressly disposed of. In other words, we are saying that the contingent, if it was residuary, we are going to take it as such unless it is written in the will of how it is supposed to be taken. So if it was immovable, for example, a property is immovable, we are going to take it at that market value. If it is a car, which is movable, we are going to take it at that value. Then we go to F, where no time has been fixed for the payment of the general legacy. So we don't have timelines. Interest shall begin to run from the expiration of 1 year from the testator's death. So where it is not stipulated, we expect that the executor will put this will into place in a period of 1 year. So where a time has been fixed for payment, interest shall begin to run from the time fixed. And we are doing this to ensure that the executor doesn't take advantage of the legatee or the beneficiary. So they are supposed to start paying immediately as per the will. So in either case, the interest up to that period shall form part of the residual of the testator's estate. In other words, we are saying that if that amount is not available, then it should be considered when we are doing the residual sharing. What remains after we do the debts, after we clear the specific, after we clear the demonstrative, we must make sure that whatever the amount that was fixed has been paid to this particular legatee. However, we are saying interest shall run from the death of the testator, where, now this is the immediate, once the testator dies, the legacy is bequeathed in satisfaction of a debt, or, so we first clear debts, then the testator was a parent or more remote ancestor of the legatee, or has put himself in place of the parent of the legatee, or what you are calling the locus parentis. He was acting as a parent in charge of the minor, and no specific sum is given by the will for maintenance. So for posterity, we are saying that if the deceased was the parent, you know, this is immediate. You cannot say that those people, the dependents of the deceased, will stop eating when the deceased die, awaiting the executor to start executing the will. No. Some of these things are so natural. If you die, we continue eating. So if you are a father and there was that daily upkeep, we expect that we will continue living. So the legacy is bequeathed to a minor with a direction to pay for his maintenance thereout. Let's say this minor was schooling. The term is lapsing when we are burying you. Are we going to wait for the will now to be actualized by the executor? No, we'll continue now meeting the expenses that were to be meant for maintenance purposes. That's what we mean. So no interest shall be payable on the arrears of an annuity within the first year from the death of the testator, although a period earlier than the expiration of that year may have been fixed by the will for making first payment of the annuity. It will be only honorable. Now, an annuity, you know, is a fixed amount of money. So we are saying, to avoid confrontation or confusion, let us give the executor 1 year to put the house in order and start paying the annuity. But if it was specific, then it will be paid as residual gift. So we might not have the money now, but that interest will be amounted and be paid in the residual gift. And then lastly, where a sum of money is directed to be invested to produce an annuity, then interest shall be payable on that sum from the death of the testator until it is so invested. So immediately, if the testator had indicated that my wealth is supposed to be put in an investment where we have a regular income, then this is supposed to be paid immediately. Otherwise, the thumb rule is, you can see from E to F, we are going to provide 6% per annum unless otherwise expressly stated. In other words, we are giving the executor 1 year to invest the money. Meanwhile, we'll be paying 6% as we wait for him to pay, as we wait for him to invest and be able to pay. Any question? Then paragraphs E to H inclusive applies so far as contrary intention does not appear from the will. So long as we are not directed otherwise, we are going to conform to what has been indicated. And you said that we are going to wait for the testator, for the executor to invest the wealth of the testator and start paying as per the will. Any questions so far? Any question? Are you people there? Joram? Mwasi?
Yeah.
I'm assuming that silence means consent. So we are talking of the protection of the property of the deceased person. There are those people who will tend to take advantage of the property, especially before the executor. Or if it was not clear, some people might take advantage. So no person may take possession or dispose of or otherwise intermeddle with any free property of a deceased person unless they are expressly authorized by the Succession Act. In other words, once someone dies, the first thing is to identify the will. If he was a testator, if he was not, or if he was intestate, had not written a will, the law of succession will take precedence. But if there was a will, we have now to conform to the will. So no person, even the father, if the son dies, your father cannot just come and start saying, I'll dispose of that was my son's property. You had challenges. The other day I was taking some trainings at the KDF, Kenya Defense Forces. And you know these people, their job is very risky. So I've been working with them for some time, trying to give some consultancy on the administration of the will, or what we call resettlement. I've been doing resettlement training for the dependents and trying to advise them how, because anything can happen when the husband or the wife is at the battlefront, it can just be, we say their death is next door. So once they receive the command, go to Somali, you don't know who will come back. So they start planning for their death once they join the military. So I've been taking them through and trying to advise, because they are taken advantage of. Let's say the father and the mother, when the son was joining the force, they were very young. Most of them joined at 22 to 24 years at most. So you find when they were joining, they were young boys, just after Form 4, some in first year, second year in college. Some they hadn't even gone through secondary education. But they've now joined. If they lose their life at the battlefront, they are supposed to be given some honoraria now from the Kenya Defense Forces. But this amount, they don't even identify beneficiaries in the will. So Mutu Akingia, when they were doing the documentation, They just indicated father, mother, then gender male, then marital status single. You see, when you say single, and then you don't update your document once you marry, when you die, the documents that are in the registry are indicating you are single. So the beneficiary of your honoraria will be your mother and father. Only to realize later when you die, you had a wife and you have 3 children. So you can imagine the tussle. It really becomes a serious case. So the first advice I give them is when you join the force, identify your beneficiary. Once you change status, kindly update your documentation. Because you've had cases where the parents even come and say, "Huyo bibi sisi hatumjui." They even start claiming anataka tu kutekia our son advantage because they are dead. So no person is supposed to take possession. But in most cases, the parents, they'll take possession of the wealth or the property of the deceased immediately. And they'll start saying, "We don't know you. Hata hujawai letwa nyumbani. Now you are telling us you are married, you have 3 children. What is that? You want to take advantage of our son." So if a person contravenes the above, he is guilty of an offense and is answerable to the rightful executor. A minute. So if a person contravenes the above, he is guilty of an offense and is answerable to the rightful executor. So if they go ahead and start now disposing or executing the properties of the deceased, where there was a will, it is illegal. And they'll be accused of intermeddling in the interest of the deceased. So whenever it becomes known to any police or administrative officer that any person has died, the first thing, they are supposed to go back to the roots and try to identify what the deceased rightfully owned. And that duty is given to the police, not any other person, to the police. So the administrative officer in the area, of course, we know the lowest in the provincial administration is the chief. The police officer labda amekuwa transferred pale na kujui, but the chief will be knowing this guy comes from certain and certain home. Baba yake alikuwa amewacha hii shamba na hii shamba walikuwa wamegawiwa wakiwa vijana watatu. So they'll be knowing. So even before that land takes or is shared to another person, the chief will already know. And that's the importance of the provincial administration. So if the administrative officer is requested by any person who appears to have a legitimate interest in the estate, or if no application for representation in respect of the estate has been made within 1 month of the date of death of the deceased, the officer will proceed to the last known place. In other words, we are saying, if we don't have anyone who is claiming the property of the deceased, then the administrative officer, who is the chief, will assume that this person died intestate. So ile kitu ya kwanza atafanya ni kuascertain from the family line to know who is the immediate family members or who are the immediate beneficiaries. So this duty is given to the administrative officer. And the assumption is, huyu jamaa hana will. So it can only be legitimate if we go to the family line in that order to know whether there are any properties, and if there are any properties, how are we going to ascertain the rightful beneficiaries? Now, if the above does not apply, the High Court has the jurisdiction to deal with any application and determine any dispute under the Succession Act. Sasa ikishindikana, if you are unable to trace you from your family line, the mandate now goes back to the High Court. High Court wakikosa, wanaweka hii asset yako in the unclaimed asset portfolio. Wakipata wenzenu ama wakipata your family line, they will decide on how the dispute will be sorted out to ensure that there is not any confusion. Then we have the application for grant. Now here we have the executor. Now, if you die intestate, there is no executor. There is no one identified who can be in charge of your legacy or in charge of the property that you owned. But we have a process that has been highlighted on how this can be granted. So an application for a grant of representation, and we mean representation ni mtu anajitolea anasema, I will chip in for this person to try and make sure that everything runs smooth. So application, or when we talk of the application for grant, we want someone to be in charge, or a probate is given a certificate of court to ensure that the will is administrated. So we are saying that probate is a certificate of a court of competent jurisdiction that a will of which a certified copy is attached is the case of a written will that has been proved, a valid will with a grant of representation to the executor in respect of the estate. Now, when you die, you draw a lot of interest, especially if you are rich. So some people will come from nowhere and say they were your rightful sons, so wanataka wafanyiwe DNA and to be considered in the sharing of the estate of the deceased. And you heard these cases, you've seen them. If you recall when Professor Saitoti died, we had some parents emerging from some place in Nakuru, I think Subukia, saying that that person didn't have a son, and we just recognized that the son who was appearing in the burial is our son whom we lost. You remember that crap? Where we had parents who were claiming that the adopted son of Professor Saitoti is their son, isn't it? So we have all these manner of interest. So if we don't have a rightful person to ensure that the interests as indicated in the will are well sorted out, we are going to have a lot of confusion. So in the application, to ensure that we are dealing with the right person, we want the full name of the deceased, the death and place of his death, whether or not the deceased left any will. Let me tell you what happens. I was once a banker, and that time before, people, just like in the army, like I have indicated, when you are opening the bank account, let's say ulikuwa hustler, to me na hukuwa na kakitu. So wewe ulifungua account yako, you even didn't care to identify a beneficiary. Then your account may grow over time. Tuseme hata ukifungua, your turnover was only 5,000. Over the time, Mungu akakubariki, umepata pesa. So by the time you are dying, you had millions and millions in the account. I'm telling you, there are those people who take advantage of such accounts. So huyu jamaa anasikia so and so ni mtajika, he was a known businessman, he's a business guru. Kitu ya kwanza ni kwenda kwa bank account na search. Samuel Mbugo is dead. We know he was a businessman, alikuwa ameinvest in shares, alikuwa amefanya nini na nini na nini. So kitu ya kwanza, those accounts used to be streamed in stream 3. So imagine an account that has, let's say, 500 millions. Na ukienda pale kwa beneficiary ni blank. What do you think will happen? So immediately the government will take that amount kwa sababu ni unclaimed asset. Wakingoja kama watoto wake watakuja kuclaim. Do you think the government will ever disclose that there is that amount? They'll gazette. Okay, huwa ana gazette zile zingine that are meager and not meaningful. But I'm telling you, the advantage was on the people who are working in the operation. So they'll make sure immediately this person is dead. Kitu ya kwanza ni kuchannel this money in some offshore account. So hii pesa tuseme naituma South Africa, ama nanunua mzigo China, container kama 20, na ziko on route zinakuja. You see, you cannot transfer this amount to your account. So you have You must have a rightful way of doing it. Of course, they are fraudsters. So they used to have even their offshore accounts in places like New Jersey, China, wherever. So where ukikufa, before your account is streamed to what we used to call stream 3, walikuwa na make sure they maximize on the wealth of the deceased person if there was no beneficiary. So we need to know the death and the place of death. Of course, you must report. You must get the burial certificate or the death certificate before the burial certificate. So that whether or not the deceased left a will. If there was a will, the relationship of the applicant to the deceased. So unasema wewe ni executor. Whether or not the deceased left any will. Now, the present address of any executors, if they are there. Some, of course, will be overseas. We'll want to know the surviving sponsors, children, parents, brothers, sisters. You see, we are now trying to open a Pandora's box. Due to do whether even the will that you are purporting exists or otherwise. So we go on. There are people who are marking my notes. I don't know what they are after. Who is putting this mark? Any question? Wewe kama uko hapo na una edit my notes na uulizi maswali. So we go on. Then full inventory. We need to know what the deceased had and any other matters as prescribed. Now, if in the application it is claimed that the deceased left a valid will, we want to see that will. So we want to see the authentic copy. See photocopy, the authentic copy. Now we need the names and the addresses of all the persons alleged to be able to prove its content. So tulisema ile will lazima ikuwe na witness. Na wakuwa wamesign pale chini. They must be reachable. We need them to authenticate that this is the rightful will. Now if it was oral, kama ilikuwa ya mdomo, the names and addresses of the alleged witnesses shall be stated in the application. And we said for the oral, the witnesses need not go to the testator ama mwenye alifanya hiyo will altogether. So what we'll do is to collate the statements. So tutasikiza amesema nini, aseme huyu jamaa mwenye alikufa marehemu aliniambia this and this and this, we record that statement. We go to witness B, we record the statement, then we try to collate. If they are differing, now things become more deep. So no permission of any information from an application shall affect the power of the court to entertain the application. In other words, we are saying this information has to be proved. So the court will not entertain just any application. So any person who makes an application and willfully or recklessly makes a statement which is false, ukienda udanganyane, you are guilty and you are punishable by a fine of 10,000. So I don't think any person will move from his house aende akatoe 10,000 yenye hakuwa nayo. Well, some people may make merry in doing this, but I don't think that anyone in their rightful mind will go and claim or witness falsely. So where a deceased person is proved, whether by production of a will, authentic or otherwise, or oral, to have left a will, now grant in respect of any property to which the will applies, now we expect that the certificate that will be provided will be giving all these and they will be annexed. So where there is no providing executor, if there is no executor who was named, letters of administration with the will annex should be provided by the court. So the court may go ahead and give you an attorney to help you go through the process. If and so far as there may be intestacy, letters of administration in respect of the intestate estate. Suppose you didn't do a will, we expect that it will be documented and we are going to have letters of administration. Of course, tuseme bibi yako or your brothers or sisters are the ones who have reported the intestate. They have to document in the letters of administration. F. Now, a court may limit grant of representation, which it has jurisdiction to make as follows. So, in all these occasions, the court will limit you. For example, if you are claiming the will is lost, so you see, we cannot easily tell. So in this case, all the will was destroyed, tuseme ilichomeka ama ikakuwa spoiled by water, na hatuwezi jua. So what the court will do, it can go ahead and request for the photocopy. But you see, we were riding on the authentic copy. But the court still has the power to prove whether this is the original will. So you cannot push them. So when the will is in the possession of a person residing outside Kenya, and they have refused to come, a copy can be used. But you see, the court will go ahead and try to as much collate what is in the original before they make use of the copy. So where there is no will, and it is not forthcoming, hakuna any will, but there is a reason to believe there is a will in existence, letters of administration may be granted, limited until the will or an authentic copy is produced. So you won't be given the powers to execute. You'll only be given letters of administration to ensure that the property of the deceased is in the safe hands. Lakini you cannot sell, you cannot dispose, you cannot share. You have to wait. So when any executor is absent from Kenya and there is no executor in Kenya willing to work, letters of administration with the will annex may be granted to the attorney. So the power will still rest in High Court to administrate if there is no willing executor in Kenya. So when a minor is sole executor, suppose the executor who was named in the will was a minor. We have to wait until they achieve the majority. Yes. So we are saying that, and the will is annexed, may be granted to the legal guardian of the minor or to such other person as the court think, until the minor has attained full age or majority age, which time and not before probate of the will is granted to him, in which case of several minors where the other reach full age. Suppose you are the executor in the will, and let's say you are 15 years. And below you have a brother who is 10 years and another one who is 5 years. So we'll put this will under a guardian, or the person we called loco parentis, who will be in charge to act as a parent until you attain 18 years. When you become 18 years, we will now make you the loco parentis of the children who are 10 and 5. So by the time you are 18, the one who was and the one who was 5 will be 8. So you will wait until all of them now reach the majority years for the estate of the testator to be now distributed to them. So when a sole executor is a person of unsound mind, it becomes very hard to deal with unsound mind or a person of unsound mind. So this cannot execute any will. So where there is a suit touching on the validity of the will, like you remember the case of Cohen and Wairimo Cohen, who was a suspect of the death of the husband. So there was a case touching on the validity of the will, because Wairimo Cohen was saying the will that is being demonstrated by the sisters is adulterated, is not the true will. So when we have such a will, or when it is contentious, now we got to now appoint, or the court will appoint an administrator to ensure that the deceased person or the the will is postulated and established as rightful before distribution of the estate of the testator. Now, if an executor is appointed for a limited person specified in the will, the probate shall be limited to that purpose. There are those executors who are said they are going to administrate the will, let's say 5 years after the death of the executor. They cannot go over and above that limit. So if an executor appointed generally gives an authority to an attorney, that attorney will take over. So you see, the executor is the person identified by the testator. They can go ahead and say, as it stands now, I don't think I'm the right person to administrate this will. So they'll pass it over to an attorney of the High Court to take over. So whenever a grant with exception or probate of letters of administration, with or without the will attached, has been made, the person entitled to probate or administrator of the remainder of the deceased estate may take a grant of probate or letters of administration of the rest of the deceased estate. We are saying the executor was given 5 years. 5 years are over, there is still some pending properties. We are going to identify an administrator for the remaining period of time. Now, if the executor to whom the probate has been granted died, leaving part of the testator's estate unadministered, a new representation will be appointed. That's automatic. These are now laws of natural justice. So when a limited grant has expired by a fluctuation of time, so the time is gone, or the happening of the event of contingency, let's say there is an emergency of whom it was limited, and there is still some part of the deceased estate unadministered, letters of administration that be granted to those persons to whom the original grant might have been made. Let's say you are in America, you are the executor. You are to fly in to execute the will in Kenya on March 15. Ndege zikafungwa because of COVID-19. Now we cannot say that because you had limited time na umekosa kukuja that you cease to be the executor. No. That's why we are talking of in the event of contingency or a happening. We'll still presume that you are going to administer on behalf of the testator. So no grant of representation shall be made to 1, a minor, and 2, no, we are saying a minor, a person of unsound mind, or bankrupt. These are very risky people. If you look at this, they can be manipulated, or they can act on their interest. For example, a minor cannot make a decision. A person of unsound mind can make the wrong decision because they are not thinking rightfully. A bankrupt person may take advantage of the situation. They are now bankrupt. There is an opportunity here to make some wealth. They can seize the opportunity. So we cannot grant representation to such people. And 2, to more than 4 persons in respect of the same person. Now, the law identifies 5 people as a meeting, as a community. So kupea watu watano one property wa administer, it will be a challenge. So the limit is 4. So your estate, however big it is, however wealthy you are, can only be administered by at most 4 people. So no grant of letters of administration with or without the will annex shall be made to a body corporate. Again, a legal person cannot administer a will except a trustee or a trust corporation. Now, a trustee or a trust, for example, a university is a trust. Did you know that? Whether public or private. And the reason why the government has made all the universities to be trustees, they've been entrusted with the body of knowledge. You cannot entrust an individual with this. So what happens is the owners of the universities will appoint a board of trustees who will be now taking care of their interest in that institution. However, the government is in charge of the policy. So all trusts, or all trustees, the government is in charge of the policy, so they can control. But for a legal person or a body corporate, you see they can sue or get sued, and a legal person does not die. So because of the dynamics of a body corporate, we cannot let letters of administration go to the body corporate. They could be interested parties and take advantage of the legacy of the testator. If you look at the Jomo Kenyatta wealth, the reason why Kenyatta family has remained rich, you know, Kenyatta went to UK and got exposed earlier. So when he came and of course invested in land, a lot of it bigger than Nyanza province put together, all these properties, the Jomo Kenyatta wealth is under a trust. To mean, not even the wife, not even Mama Ngina, or even Uhuru can go and say, I'm going to sell. And that is one of the things that have really helped them. Because when you are under a trust, there is it's so structured. There is a lot of bureaucracy before you even get through. So all the wealth of Mzee Jomo Kenyatta and family is under a trust. So when we are talking of the letters of administration, even if anything happens now to Mama Ngina or even the son or anyone in the family, their wealth is still safe because it is being administered under a trust corporation. So when you become wealthy, consider yourself or your wealth being put in a trust corporation. It is the safest. And we are coming to trust laws thereafter. So no grant of representation shall be made to a syndicate. Now, syndicates are these groupings or the investment companies, like land buying companies. So if we take your property to a syndicate, the next thing they'll do is try to take advantage of it before the beneficiaries get hold of it. So a person who has been appointed by a will as an executor may either by oral declaration before the court or by writing under his hand denounce executorship. Unaweza kataa and thereafter be precluded from applying for grant of probate from the will. Kuna mahali unaweza angalia uone hii mahali nilijiweka inaweza kuwa mbaya. I was giving you the story of the Kirema family or even the Jenga Karume family, where there is a lot of wealth, but the spouses and the children are still fighting. They are unable to get through. Now, if you are the executor, and these people are very powerful, they can even plan for your murder. They can send hitmen to kill you. Kwa sababu wewe ni wewe umezuia wagawane mali ya marehemu. So what you can do, the best thing to do, if you identify that these people will never reconcile, you can resign from being an executor. So you can denounce your executorship. So where several executors are appointed, probate may be granted to them all simultaneously or at different occasions. Now, depending on what has been expressly documented. So where deceased has made a will, but he has not appointed an executor, or the only executor appointed are legally incapable of acting, or have died before the testator, it can happen. Or providing executors have died before completing administration, a universal residuary legatee may be admitted. Of course, we are assuming that if this process of trying now to get the property to the right people was not concluded by the executor, there should be really a mechanism to ensure that this property goes to the rightful owner. So when a deceased had died intestate or without a will, the court will have a final discretion as to the person or persons to whom grant of letters of administration is made in the best interest of all the concerned. Of course, there is that process that we indicated of the intestacy. They'll start with the father. If father is dead, mother. If mother is dead, brothers. If brothers are dead, sisters. If sisters are dead, now these are the blood brothers and sisters. They'll go to the step brothers and sisters. No, to children first. They'll go to children. If children are not there, they'll go to step brothers and to remember that process of intestacy. It is in the laws of succession. So as a general guide, the following order of preference is given. So you have the surviving spouse. With or without association, we have the other beneficiaries, and I've indicated other beneficiaries entitled on the intestacy with the priority as per the intestacy. Then, if that is not available, if they are not there, we may put this to the public trustee. If not there, we now consider the people who are purporting to be indebted. So when there is a partial intestacy, letters of administration in respect of the intestate shall be granted to any executor who proves the will. Let's say you had provided for your property, let's say the property is worth 50 million. What we can trace or what is in the will is only accounting for only 35. So it's like properties worth 15 million are not considered. That will be partial intestacy. So the letters of administration could be granted as long as there is a proof there of the will. Then you have the duties. You can see the powers and duties of the personal representative or those who are presenting. So now this is explicit. Unless we have any question, I beg to wind up the class. Then we go and respond to the forum in the portal. Don't know whether it has normalized. Any question? As I wind up, I have another class at 11. Kindly explain what is abatement. I said abatement is fail, decline, or when it cannot be put into use. When the legacy cannot be put into use, it is dead. So Mwasi, are you okay?
Yeah.
Mwasi, is that clear?
Yeah.
Any other question?
No question.
Any other question? So in absence, any other question? Thank you for your time. I wish you a fruitful day.